right. Good evening, good morning, good afternoon, ladies and gentlemen, from wherever you're tuning from. Thank you so much for making it here tonight. We're really excited to have you and, of course, to have this conversation. I think it's been a long time coming, and we are hoping that it's as impactful to you as it will be for everybody else. And my name is Grace Nzula. I'm an HR consultant with Atara Solutions. Atara Solutions is a HR consulting and training firm. We offer HR consultancy where we can support you in doing your job evaluations, in recruitment, in HR audits, in documentation for your staff members. Are you looking for contracts? Are you looking for policies, either reviews and update or just preparing them from scratch? Would you like to have HR systems in place? Then we are the people for you. We also offer recruitment and selection services or talent sourcing, where we support you in recruiting your team members. We also offer what we call HR manager outsourced for organizations that don't require a full-time HR manager. And of course, we are into learning and development or trainings for all your human resource. We are technically a one-stop shop for training. So please do not hesitate to join us, or rather get in touch with us, and we'll be able to support you in one way or another, especially on People Matters. Now, tonight, you're tuned into a program we call Get It Right with Atara Solutions. Get It Right with Atara Solutions is a webinar series that seeks to demystify issues in employment and entrepreneurship. We do this every Tuesday from 8 o'clock for the last 5 years. Actually, we started in 2020. And we have done this every week, every Tuesday. We normally start in January and take it all the way to November. And we discuss different issues that affect both the employers and the employees. And we're excited that you could find time to also join us for this conversation. Of course, I don't do this alone. We have our sign language interpreter who is currently on leave. We are thanking God for Catherine Sidandi, and we are looking forward to her coming back soon. And of course, with my co-host, Richard, I will allow him to introduce himself.
Good evening, ladies and gentlemen. My name is Richard Magoma, and of course, the things that I love doing in this world is training people to speak very well so that you can get those very interesting and attractive opportunities. And I also prepare people for interviews so that you do not have resentment. Don't just go into the interview without preparation. It is war. You can imagine how many people graduate and you are going with your CV without reading it. Thank you very much. We are here to see whether we Africans can be able to write wills, which is very difficult for Africans. Thank you, Grace.
Thank you, Richard. And thank you very much for also just being a co-host and for being here every Tuesday as well. We don't take it for granted. We really, really appreciate. So allow me to also just quickly let you know the activities we have in Atara Solutions right now, so that you can spare a minute or two to just join this conversation, or just take care of your organization as well. So we have discounted rates at this point in time for job evaluations. So we currently have discounted rates for job evaluation services. So please do get in touch with us to know what that means. But job evaluations will help you come up with job groups for your institution and salary scales. And then we normally combine this with the salary survey. However, those can be two separate services. So please do get in touch with us to get to know what is on offer for you for this service. And of course, we have legal intrigues, common pitfalls in performance management. Where are the gaps that most of you have on matters performance management? And this will be happening on Thursday, the 16th of April from 2 o'clock to 5 o'clock. with Anne Babu. If you know matters legal and employer employment laws, you know about Anne Babu. I keep telling her she really took us through COVID time when we didn't know what was what. So we will be hosting her. We are partnered together. You'll get to earn 1 CPD point from IHRM, and of course a soft copy certificate for all those who attend. Besides that, it's an opportunity to ask as many questions as you possibly can, and it's going to only be for 3,000 for the 3 hours that we'll be together. So please sign up, and I know Paul will put in the link on the chat. All right, those are the 2 activities from Matara Solutions. And now, for the moment we've all been waiting for. This has been a conversation with my friends for the last 1 year. And of course, with my colleagues, we've been talking about it on how to really secure your future, or rather the future of your family members. And because we also have all these African beliefs that we have normalized, we want to hear from the experts what exactly it means to write a will or just protect your assets in case you are not around, which I think I know in the African setup, we don't like talking about that because for one reason or another, I don't know what we can say about that. But yeah, here we are. So with us is Mupa Mbetsa. She tells me she's a combination of Uganda and Kenyan. So we are excited that our Ugandan family, you are well represented. She is an associate at O&M Law and an advocate of the High Court of Kenya. She's also a certified professional mediator. She focuses her focus is on family law, where she works on advancing justice, safeguarding rights, and supporting those navigating complex family-related issues. She's deeply committed to using her legal expertise to promote fairness, healing in dignity. She's equally passionate about mentorship and enjoys engaging with young people to share insights on career development and professional growth. So, ladies and gentlemen, we have Mupa. I hope I'm pronouncing your name right. Okay,
yes,
Mupa
yes.
Mbetsa. Yes.
You.
At least I know them better because Joanne Mbetsa is my friend. So at least I know how to pronounce that other name.
Okay.
But yes, but here we are. So take it away and tell us how we can safeguard our family's future.
Thank you so much for the introduction, and I believe we can take it away. As mentioned, my name is Mupa Mbetsa. I'm an advocate of the High Court of Kenya, and I'm a family law practitioner. And yes, I think we can go ahead and start the presentation. So today we'll be discussing estate planning and succession, as has been mentioned. And maybe just a brief exercise as we go through this presentation is to ask yourselves, if anything were to happen to you today, this minute, or maybe later at night as you go to bed, for those where it's at night, how will you have left your beneficiaries? Will your estate be handled efficiently? What assets do you think people might not know of that you've maybe never mentioned? And what would be done to them? So this discussion is to help you introspect and possibly at the end, have a discussion with us at our offices to help you come up with a plan that is suitable for you and for your needs. And so what exactly is estate planning? I know this has come up quite in many conversations, and just a brief introduction is that estate planning is preparing for the distribution and management of a person's estate, and not only at death, but also in case of incapacitation. And this could be because of physical illness, old age, or whatever circumstances that may be present that will make you unable to run affairs as you would have if everything were okay. And just because we're doing estate planning, it doesn't guarantee the absence of any family feuds that may occur over your inheritance, but it can significantly reduce the possibility of these disagreements and preserve the estate left behind. And so why should we be so keen in estate planning? We want to protect beneficiaries because we're not working so hard for everything to go back to the government or to be wasted. We want to minimize estate taxes and the legal fees that we end up paying lawyers in dragged out court processes. We want to ensure smooth succession and asset distribution, as well as prevent any family disputes that may occur. The problems estate planning is seeking to solve are mainly preventing disputes over inheritance by providing clear instructions. You want to let all the people you love, your loved ones, know what exactly they are getting and why they are getting that. You want to prevent loss of wealth from debts and mismanagement, because it will fall in the wrong hands, and this will, delay everything that you might have worked so hard for. You want to make sure that neglected dependents, children, spouses, and vulnerable family members, those with special needs, are cared for just as they would have been when you are alive. You also want to ensure there's continuity of family businesses through planning and to prevent business collapse, and ensure that your personal, cultural, and charitable intentions are honored. Currently in Kenya, there's quite a sad state of affairs, in the sense that succession planning is myth to be for the elderly, or the super wealthy, which is not the case, because intestate succession takes way too long, and many families end up being at the mercies of courts because everything is frozen, nothing can be dealt with. You will be shocked to know that only 10% of Kenyans have formal wills. Yet this is the most popular mode of estate planning. The reason for this is because there's a high dependence on customary law and intestate succession. We don't want to think about our futures because we're like, you know what, after all, I won't be here, and so what does that matter? And it should, because now people are fighting for the very things you worked so hard in your life to ensure everybody lived comfortably. But in opposite of that, it has just caused conflict among people. And the reason this is happening is because there's a lot of fragmented legal and financial advisory services, and that is what we are trying to streamline and ensure is taken care of on our part as legal practitioners. Why should you prioritize estate planning, you may ask? One, because there's a rise in middle class and high net worth individuals who contribute way too much into the economy for it to all just go into waste. Secondly, we have many complex families. We have blended families, people in estranged relationships, polygamous unions, and special need dependents who will need to be taken care of upon your demise. There's a lot of cross-border asset acquisition in families. And so you have a situation where you've worked in the UK, somewhere in Europe or the US for so long, acquired assets there, moved back home to Kenya. You don't know what you're going to do with the assets there, and so they're left to go to waste. This is what you've been trying to own all along. There's also an increase in women's asset ownership. And because of this, we come from a society where before men were the only ones who could own assets. Now we have women who can own assets in their own individual capacities, if not in joint capacities with their spouses or even other loved ones. And because of that, we need to be sure that when they're no longer here, everything of theirs is well taken care of. One thing we need to remember as we go into this discussion is that estate planning isn't just about who gets what. It's about the transition of leadership and responsibility, and especially for family businesses. Now, estate planning can be done individually or it can be done with families. And I will go into the individual's estate planning in a short while, but maybe just to discuss briefly how estate planning for families would look like. First things first, the family will need to sit down and discuss their goals, come up with the values that guide them, and maybe come up with a family charter or a family constitution which outlines these goals and values. Once this is done, they consolidate and value all their assets. This could be the pool where all assets of the family are put together, or individual assets are put to look like they're belonging to the family. We then create a family trust or a joint will. I need to mention that joint wills only occur in situations where people are legally married. Remember, cohabitation is not a form of marriage in Kenya, and so you need to be legally married for you to qualify to have a joint will with your spouse. While we're doing this, remember we've said that estate planning is not only at the point of death, it could also be at the point of your incapacitation. And so what you want to do even before this happens is set up education and emergency funds if you have people who are still going to school. Secure digital accounts. Maybe you have a great social media following that you'd want to continue even after your death. Your M-Pesa is part of a digital account. If you have cryptocurrency in any form, that also forms part of your digital account. You also have an opportunity, to plan for giving and legacy, because at the point of intestate succession, that is dying without a will, courts don't care that you are donating to this specific charity. They already have a set standard set by the Law of Succession Act, and so that is what they will go by. You would have wanted to donate to a certain charity, but you're not given that opportunity if you had not mentioned it earlier in a will or a trust. Another way for families to start planning this is to hold regular family planning sessions. And the reason for this is because different things trigger the need to change the charter or the constitution you've come up with as a family, or even the family trust. An example of these triggers could be birth in the family. It could be that one of the children has gotten yet another child, and so now you have grandchildren who you'd want to provide for. It could be that there's marriage or divorce that had happened between the parties of the trust. So one of you has either remarried after a divorce, or you're in a polygamous union and have brought in somebody else into the picture, and you'd want for them to be provided for. It could be that the business that you have, the family businesses, have grown, or you've sold them, and so they no longer form part of the assets you can include in your trust. There could also be a change in laws or goals, or debt, or even death. And so all these things will necessitate that you change or come up with a review for the family trust or charter or constitution, whatever you may choose to call it. And so I will go to the modes of estate planning. Like I mentioned, estate planning does not only happen at the point of demise or in contemplation of somebody dying, but it could be at the point where you think you're old and are not able to handle your affairs well anymore, and so you want to do some things prior to that happening. How do you first go through this? How do you come up with the method you're going to choose to do your estate planning? One, you want to ask yourself these questions. Who needs to be cared for during this time? Who will be the beneficiaries of whatever it is you're leaving? Who have you been working so hard for all this time? Secondly, what assets need care and attention? What have you managed to gather in all your years that you want to allocate to people? And who do you want to have this authority to care for these people? That is, the guardian or the fiduciary of the trust or the will you'll be creating. Fourth, what specific authority do they have? Can they do anything on their own? Do they need the assent of all the other beneficiaries or fiduciaries? How long are they to have this authority? And how would you prefer that they use it? So as you think through these questions and give answers to them, you then come into the different modes and how you can choose which one works best for you. The first one is joint ownership. Joint ownership is provided through the Land Registration Act in Kenya. It is also provided for in the Ugandan Registration Act for land, and this is just the registration of property in the joint names of an owner and a beneficiary as joint tenants. I'll repeat that. It is the joint ownership of property in the names of an owner and a beneficiary together as joint tenants. This means that in a situation where one joint tenant passes away, the share of that property that they have, so 50%, automatically goes to the other surviving person without any legal process. All you need to do is furnish the Registrar of Lands with proof of death. A key reason why people use joint tenancy is to avoid probate. Like we've said, if you don't plan your affairs well and you die without a will, meaning you died intestate, it could take up to years, maybe even decades, like we've seen with some notable families, 40-something years, for people to get just a small share of the estate. And so instead of waiting for several months for probate to be resolved, joint tenants can access assets immediately and at minimum costs. This is very different and should be separated from tenancy in common, where upon registration and you are tenants in common, when you die, your 50% goes to your estate. And so we need to make a distinction between joint ownership and tenancy in common. The second method of planning your estate would be through gift inter vivos. This just means giving somebody a gift while you're still alive. You have ownership of that gift, but you know your time is nearing or things are not looking so well for you. And so what you do is you gift somebody this gift well in advance your demise. Worthy to note is that in intestate succession, meaning in succession where you've done without a will, when the court is determining a share that is to be given to a beneficiary, the court will take note of all gifts that had been given previously. And so to avoid the long probate process, what people do is gift their loved ones well in while they're still alive. This doesn't mean that you're completely ceding ownership, but you're just saying, look, upon my demise, this will be yours. This is different from a gift in contemplation of death, which a gift in contemplation of death is made on condition of the donor dying, meaning this gift only takes effect upon the death of the testator. Differentiate that with gift inter vivos, which we have said is a gift during your living time. You're still living, you're still in good health, you give away something. A gift in contemplation of death, you give away something, but on condition that this gift only passes to the recipient upon death. And you need to give a symbol. It's one of the requirements of the Law of Succession Act that you need to give a symbol to the person who is to receive this gift that you intend to gift them upon death. For example, you want to gift one of your daughters a car. What you do is you give them the car key and tell them, upon my death, this car will be yours. Somebody needs to witness it. It doesn't have to be in writing per se, but there needs to be somebody witnessing that indeed this happened. Or you could say you have your title deeds here, and so upon my death, I want this property to go specifically to you. Just the act of stating where the title deed is to this one person with a witness present qualifies it to be a gift in contemplation of death. Another way of planning your estate is by nomination. And this is a direction to somebody to give specific things to somebody else, your beneficiary, upon your death. You will note that retirement benefits, insurance policies, and such like do not ask for just the next of kin upon your death, but also for a nominee. This is because nomination gifts do not go through the process of probate. They go directly to the nominees. And so this person is entitled to the funds or the investments you have made by written nomination immediately upon your death. And like I've said before, certain things like retirement benefits, insurance policies do not constitute part of the estate and will be paid out directly. A key mode of planning is a trust. A trust is an entity created for purposes of ensuring that a property interest held by one person, who is the trustee, at the request of another, a settlor, is for the benefit of a beneficiary. Many times people prefer trust because a trust is a separate legal identity from its person. And so you have your property because you don't want anybody touching this property. You transfer it to the trust and the trust now starts owning this property. Being a separate legal identity, it operates like a company, meaning it has its own identity, it can sue, it can be sued, it can earn income, it can settle debts, and things like that. And so it's really tight locked in terms of security, because when people are coming for your estate, your trust is not part of your estate. Like we've said, a trust is a separate legal entity. It's a juristic person in and of itself, and therefore it cannot be challenged if properly constructed. Lastly, but definitely not the least, we have wills. Wills are the most popular mode of estate planning. Yet, like I earlier mentioned, only 10% of adults in Kenya have wills. And what exactly is a will, and why is it important? A will is an expression by a person of his wishes regarding the disposition of his property, intended to take effect only upon their death. So you as the testator, a person who writes a will, is called a testator. It doesn't limit your right of ownership to make this will. And what I mean is, many times the myth is you don't want to write a will because you think by saying so and so is supposed to inherit this, you stop having ownership over that property. That is not true. All that happens is that you're saying upon your death, this is how you wish for things to be distributed, your remains to be interred, or whatever the case could be. Remember, a testator has complete testamentary freedom. And if a will is validly executed and attested, it is more than likely to be upheld. What exactly does this mean? It means that should you wish for a veterinary, because your favorite thing in this world is your dog, and so you want the person who's taking care of your dog to have all the property, you're free to do so, provided you have stated why these other dependents of yours are not getting anything, because maybe you had gifted them during your lifetime. And so that's the flexibility of a will. It allows you to state whatever it is you would intend for your property, for your things. And it's when we talk about property, we're not just talking about land, because I think that's what is reduced here: land, cars, maybe shares. We're talking about anything. It could be that you have jewelry that is valuable. It could be that you are a collector of books or vinyl records. Whatever it is, you're free to dispose and bequeath as you please in a will. However, we need to state that there are certain conditions that will make your will become less valid. An example is a will being revoked by marriage. For example, this is a case where you make your will as a bachelor. However, 3 months down the line, you get married. Your will automatically becomes invalid unless you make a clear provision in the will saying, in as much as you're a bachelor now, you are intending to marry so and so, and you have to specify who it is, and that's why as your wife, they can inherit based on your will. A will could also be interfered with if it does not make reasonable provision for a dependent. And many times, who we call reasonable dependents here are children who have not been disclosed for one reason or another. It will not invalidate the will per se, but the court might be forced to alter your will to ensure certain people are able to be provided for because you left them out. And so to avoid this entire mess, what you want to do is to make sure everybody has been disclosed, all assets have been disclosed, and you're now living in harmony if that's the case. There are cases that I've quoted that have provided for this position. And maybe just to give a brief one, we have Ndolo versus Ndolo, where the High Court had invalidated the deceased will. The facts of the case were that Mr. Ndolo had 3 wives. However, he left a majority of his estate to his 3rd wife, leaving out his first 2 wives, despite being polygamous. Please note that I am not saying ex-wife or ex-wives. These were all his wives because he was polygamous. The Court of Appeal held that inasmuch as the deceased was entitled to dispose of his property as he pleased, he was also entitled to leave his 2 wives with reasonable provision. It is undoubted that his 3rd wife was his favorite and he allocated her a larger portion, but they had to be provided for. The 2 others also had to be provided for. This is not a bar though. This doesn't mean that if you have an ex-spouse, they have to be provided for in the will. Even a current spouse can be left out in the will. And an example would be having an exclusion clause where you're saying you've intentionally excluded someone from your will because of A, B, C, D, and that it is not an oversight. You've done it intentionally. Also remember, as a testator, as you're writing this will, you're at liberty to show preference. Maybe you have a favorite child or grandchild. You don't have to be just and fair when it comes to writing your will, provided you give reasons as to why you're doing that. We can also have funeral directions be dictated in the will, and many times court uphold these decisions of the deceased person. Because people comply, it becomes very helpful. We have seen a reduced number of burial disputes in the magistrates' courts. And this is because, again, the uptake of writing wills has been taken very well by the public and is something we all need to consider. Just a few tips when it comes to your will. Once it has been provided and once it has been drafted, and you can be sure that it will be valid upon your demise, make sure you keep it away from the beneficiaries. And how can you do that? You can have one copy with the lawyer or the drafter of the will, have one with one of the people who you've mentioned as an executor, or have it in a bank. But it is always important to know and let other people know that you have a will and where to find it. It would be quite useless for you to have made a will and nobody can trace it because they did not expect for you to have one. And so what ends up happening is your estate keeps going through intestate succession. I will take questions at the end. Sorry, I forgot to mention that. And so we can continue, and once I'm done with the presentation, I'll be able to take any questions you may have. Now, let's go into the law of succession. What exactly is it? It deals with how property, debts, rights, and obligations pass upon the death of an individual. Now, we have 2 types of succession: testate succession and intestate succession. When you die with a will, we say you have died testate. When you die without a will, we say you have died intestate. And many people in Kenya die without wills. We've already seen why earlier on in the presentation. The disadvantage of this is when you die intestate, the matter is taken off your family hands, so to say, and the court is the one that dictates, based on the Law of Succession Act, who is going to take out the letters of administration and who is going to benefit from your estate. And the priority normally is a surviving spouse will take out the letters of administration, and then the other beneficiaries. So these are children, siblings, the public trustee, or creditors if you had some. You will notice that many succession matters usually escalate and take way too long, and we all wonder why. The first reason is because many women, especially married women, are usually disinherited. We come from a society that believes that married women cannot inherit from their fathers. And the rationale behind this is they're probably going to inherit from their husbands, and so what's the case? Time and again, courts have upheld that married women can inherit. And so the modern legal reality is clashing a bit with traditional expectations, and this gives a rise to succession matters escalating. Another reason why succession matters escalate the way they do is because of pure greed. You've already been allocated a certain share, but because you want to have more than so and so, or just, for the sake of it, you go and challenge. And yeah, you have people in drawn-out legal battles for no reason, just because you want to have more, which is quite the irony, considering this is not even your property to begin with. Somebody has bequeathed you, you feel entitled to somebody's property. Another reason why succession matters escalate is because there are many undisclosed spouses and children. It is not a rarity where somebody has passed away and you find out that they had a child, a spouse who have only come out at the funeral. And so as you rush to court as the legal spouse, you're quickly stopped by these other people because they also want to be reasonably provided for in the estate of the deceased person. Another reason is people don't acknowledge that the gifts that they received from a deceased person during the deceased person's lifetime is considered during distribution. And so upon the death of this person, they want to have more. The last reason why things escalate is intermeddling. And intermeddling basically is knowing fully well that a deceased person is no longer there, but continuing to operate their estate without the proper legal grants that you're supposed to get from the court. And so everybody wants a share, but no one wants to do it the proper way. And mind you, intermeddling is the only criminal offense provided for in the Law of Succession Act and carries such a hefty fine. And so we need to be careful before we keep, running around affairs of deceased persons without the proper documentation from the courts. Under the Law of Succession Act, like I mentioned, if you die without a will, the law will dictate a very rigid formula for distribution that might not even reflect your actual wishes. So there's a certain hierarchy that is provided for in the Act where maybe you are not married to somebody, and so the Act will not recognize them as a wife, but it will recognize a third cousin, and they will be entitled to inherit from you than your life partner. You also need to know that a man is considered married to a woman if they have lived together, even if they've not formally wed. Like I said, cohabitation is not necessarily marriage, but if you prove certain conditions and this woman comes to court and claim, listen, I was a wife of the deceased, more likely than not, the court is said to agree with them. And because of that, anyone, including the children of this woman, who was being maintained by the deceased immediately prior to the death of this deceased person, can move to court to claim a share of the estate. It is therefore better to acknowledge and provide for them in a will than to have an entire will set aside by a judge later. And I will end my presentation here and take any questions that have arisen.
Wow. That was quite an interesting conversation beginner. And I think going by the questions, of course, we're going to ask, I think we need to do a session on trust, but we have a few questions around that. So one question that came in when you're talking about somebody who can become a witness is what happens if the person who was a witness decides not to be a witness? And please, you can put the questions on the Q&A so that it's easier to follow, because sometimes we lose them on the chat. But Mupa, what happens if the person who was a witness decides not to be a witness anymore?
I don't think you can choose not to be a witness, because what witnessing does is saying you were here when this person was signing the will. I think what they want to ask, and maybe they can correct me if they're wrong, is if you've been chosen to be an executor of an estate and you choose not to. An executor is a person who administratively runs that estate to make sure it moves to the beneficiaries. And in such a case, the law provides that you can renounce yourself as an executor. There are actually forms you fill declaring, I don't want to be an executor in this estate, pick somebody else or find somebody else within the family to do that. However, for witnessing, it is only for purposes of validity of the will. And so your work is done at the point of signing that will.
Okay. What is the difference between a foundation and trust? There's also a foundation trust. What is your take on this? Please expound.
A foundation is generally for the public, whereas a trust is limited to the people who you can include. A foundation does not have to disclose the exact beneficiaries. It could be all the poor people in place A, B are to benefit from this foundation. However, for a trust, you have to specifically name all the beneficiaries and how they are to get their assets from this trust.
Okay. From Hudson Shiverenje, is it allowed in law for the family to sit and agree on sharing the estate instead of going to court?
Hudson, thank you for your question. Yes, I think that's what we were discussing when we said estate planning for families would require that the entire family sits down together, comes up with a family charter or a family constitution, and then you can appoint somebody to have a will, or you can have a joint will as a family and see how you're going to manage the assets upon the demise of any of the members.
Okay. Can one write the will? This is from Julia Kagia. Can one write the will and video record themselves narrating the will? Is it legal?
Okay, so now maybe I should make a declaration here. There's two types of wills. There's an oral will and there's a written will. An oral will is only valid for 3 months, meaning it will only be valid within the 3 months before you die. And so if you're not dying within 3 months, your oral will becomes invalid. For a written will to be valid, it has to be signed by 2 people. It has to be witnessed by 2 people, sorry. So it has to be executed by the testator, and then it has to be attested to by 2 witnesses. And so if you video record yourself narrating the will, we'll take that to be an oral will. And should you not die in 3 months, then your will becomes invalid. It is not illegal, you just will die without a valid will. And so we go back to intestate succession. And so the recommended approach is to have a written will, preferably by a lawyer, because they will be able to guide you as to how the will structure is to be. Although you could also write your own will wherever you may be, but make sure it meets the legal requirements provided for in the law of succession.
Okay. Okay. I was looking at a very interesting question here from an anonymous. What can I do if I have worked with my husband, contributed financially in acquiring land or property, but he later becomes polygamous and wants to exclude me on such property?
Okay, that comes through matrimonial property, and maybe to talk briefly on it. Courts have time and again ruled on what matrimonial property is. But basically, any property that has been acquired, developed, or maintained within the pendency of a marriage qualifies as matrimonial property. However, the Supreme Court recently, in 2024, came up with a decision where it is not obvious that the contribution to the acquisition, development, or maintenance of these properties is 50-50. And so you must prove contribution. The presumption is this property is matrimonial property, and so the burden is on the other person to say, no, this property is not. However, on your own, you have to prove contribution. Contribution can be 2 ways, monetary and non-monetary. Monetary is literally what it just means, cash. How much cash did you give for this property to be acquired, developed, or maintained? Non-monetary contribution is now every other thing that you did to help in the acquisition of this property. Did you take care of the children? Did you provide companionship? Were you doing domestic work at home? Were you managing the home? Were you managing family businesses? All this, and you can understand that it is very hard to give a figure as to what non-monetary contribution is. But the question would be, would this person who's saying, no, it is not matrimonial property, have acquired this property without your non-direct contribution, without you taking care of these children, without you washing the clothes or managing the family home? Would they have been in a position to acquire as much? Definitely, it will not be 50-50 unless you have the cash or receipts to prove that, but the courts look into all of these things prior to making the decision. And so your best bet right now would be to try and separate your assets from what he has done, because upon succession, if the properties were registered in his name, the court will divide even that which you acquired with him before he got into these unions equally among all of you. We have what we call the house system in Kenya under the Law of Succession Act, where every wife and their children is considered a house. And so what the courts will do is it will see all the total assets of the estate and distribute it among the different houses. The reason you want to avoid that is because in succession in Kenya, if you die intestate, meaning if a man dies without a will, right? As a wife, you only have a life interest in the property. The property is not yours. The property is for the ultimate benefit of the children, and as a wife, you're only holding it in trust. I hope that makes sense. I'm saying that upon death of a man in Kenya, and he died intestate, meaning without a valid will. As a wife, you might think you're entitled to that property because he was your husband. That is not the case. What will happen is you will have a life interest. As long as you live, this property will be yours, but it will never belong to you legally. It belongs to the children, and you're only enjoying it until you die. It will not go to your estate upon your death. I hope that makes sense.
Yes, it does. There's a question that was asked by Sahil Java. Says, please tell us more about joint wills. How does it work?
Joint wills work the same way as individual wills, only that you're swearing as two testators because you have joint property together. And so it's two testators, but still the same number of witnesses. It follows the same rules and laws as an individual will would. It's the same, only that now you have two testators, you have two people signing a will, and whoever dies first, as how it will work is whoever dies first, because the estate is presumed, the joint ownership is presumed that when you die, it goes automatically to the other person. In the end, it will become one will, so to speak.
Yeah, I'm wondering
Yes.
what happens in Uganda. Anyway, back to today.
Yes.
My dad let me manage his estate before death. He handed me the title deeds, and after his demise, one brother is demanding to manage and be given the titles. The rest of us say no, but now he's issuing threats. What can we do?
So when you go to court in such a situation, if you are to be the administrator of the estate, all other people need to sign consents. They need to consent because you're all of equal priority. Your brother and yourself are of equal priority. Had it been your mother, that's a different case because she's of a higher priority as the spouse to the deceased person. And so what happens is in such cases, the court will say fine because there's a conflict and not everybody is agreeable to you having, the legal mandate. I will give both of you, you will be joint administrators. And so in court, the court allows for a minimum of one, but a maximum of 4 administrators in an estate matter.
Interesting. There's another question. Do the courts recognize deathbed written instructions, which are witnessed and signed by all beneficiaries in the presence of a witness?
Sorry, please come again. I think I missed
Do
that.
the courts recognize deathbed written instructions, which are witnessed and signed by all beneficiaries in the presence of a witness?
Yes, it would suffice to be a valid will. However, a minimum of 2 witnesses would be required, and the 2 witnesses, maybe I should mention, cannot be beneficiaries. So if you're in a deathbed and you do make a declaration that is then written, meaning you're coming up with your will at that moment, we'll call it that, may be called 2 external people who are not beneficiaries to witness this will, because the witnessing of a will by beneficiaries invalidates it. A beneficiary cannot witness the will unless somebody else again witnesses that they witnessed it. It's a whole other thing. But a will can only be witnessed by 2 independent witnesses who are not beneficiaries of that estate. Yes.
Can a second spouse who lives in this first spouse's house claim the property as their matrimonial house?
Can a second spouse who lives in the first spouse's house claim the property as their matrimonial home? They both live there, or where is the first spouse? Maybe we can clarify that.
Maybe we need clarity on that, yeah. As we wait for that clarity, we can take another question. Would monetary contributions that the spouse provided from a joint bank account to buy property be enough as contribution?
It would be, but the problem with joint bank accounts, or at least what the courts would want to see is, the courts would want to see your investment or your contribution to that joint account. Because it cannot be that I contributed 10% and my spouse contributed 90%, and we are saying because it was coming from a joint account, we are entitled to the same. And so you have to show what was your contribution to that joint account that eventually ended up buying the property.
Yes. Can a will be revised?
No. No, yes. A will cannot be revised by an individual. And okay, maybe let me qualify that statement. And I'll give an example to do that. If I write a will and a certain circumstance changes, yes, I am able to go back to whoever drafted my will and tell them this has changed, and so I need it updated. However, once I'm dead, I cannot revise a will. Whatever I had written has to pass. Yeah, and so a will can be revised as many times, and so you can have codicils. We call them codicils, which is an amendment. So you have your original will, and then you just keep adding the pages to show that you've amended it time and over again. And so yes, the short answer is yes, a will can be revised, but I would advise that you reach out for personal, it goes on a case-by-case basis.
Yes. All right, so clarity on the house of the first wife and second wife.
Yes.
First spouse passed away, but the first spouse had grown children, and the second spouse moved into the house. So can they claim?
If the first children are not claiming it, they can. But if the children from the first spouse are claiming it, it legally belongs to them. And so I guess it's a question of ignorance. Are they aware that it is entitled to them? Morally, are you inclined to disclose that to them? I think that's a personal question only they can answer.
Yeah. If my father gives me vehicle documents, you may need to clarify this. If my father gives me vehicle documents as a gift, and later in the will, will I see the gift inter vivos? Does that mean the vehicle was my gift? Okay. You have confused us on the vehicle. Kindly clarify. Let's move on to another question. Richard, any question as I look for the others?
Very much, Mpa, for that wonderful demystification on issues of the will. The questions I have, are there basic principles that a person should observe when drafting a will? And if they are not observed, then it becomes a problem to courts to apply. Basic principles that classifies one as a good will and the other one as a bad will. Two, what happens to the liabilities? How are liabilities distributed in the will?
Okay, maybe I can answer. Basic principles of a will: you must be an adult to be able to make a will. You must have capacity, that is the mental capacity. And so you have to be mentally sane to write a will. For the will itself to be valid, it has to be executed and witnessed by two individuals who are not beneficiaries of the will.
The second question was, what about liabilities that the person who is writing a will that possesses, how are they disposed of?
Oh, sorry. So normally in a will, what goes to the beneficiaries is the net estate of the deceased person. So liabilities are taken out first, and then the estate that remains is what is distributed to the beneficiaries. And maybe I should mention, sometimes we write wills and maybe we acquire property and we forget to update our wills. And so many lawyers will have what is called a residuary clause, where you're saying any other property which I have acquired after the execution of this will, meaning I have not mentioned it in this will, I would like for it to be distributed in this and this manner. And so, yes, liabilities are first removed prior to the net estate being distributed. And then if there's a residuary estate, it is also included into it.
Probably as the last question, what if somebody interferes with the will or forges some details of the will? What happens?
I think I would need more details on that to be able to advise, because how do you know that the will was forged? Is it that the signature is different? Is it that there's properties that's been included that don't belong to the deceased person? Perhaps that person could reach out and we can discuss this further.
Right. Speaking of reach out, you can share the contact details. There's one question here that we really need to ask before we are running out of time. If there is funeral directions, can I open the will to establish what the content says when the person has passed, especially when 3 others have it? If there are funeral directions, can I open the will to establish what the content says when the person has passed, especially when 3 others have it? Okay.
Okay, so yes, a will is only takes effect upon death. And so once somebody dies, you are free to open the will of that person and see what it is that they had intended to happen at their funeral. But maybe at this point, I can also add that there are certain other things other than a will that you can include when you're leaving, that you could include in your estate planning. And these would be one, like our living will. So we will call it a living will in quotation marks, meaning sometimes you're in hospital or somebody is in hospital and you're not sure what they would have wanted. Do they want to be kept in, on the oxygen incubator, whatever? And so what you could do is provide a living will that directs how you want to leave the world, so to speak, right? Maybe switch off this after this number of days or hours, or don't take me to ICU, or don't try to resuscitate me, because remember, a will only takes effect upon death. And so what would be happening previously, you would need to know. Another thing you want to have is, even as you're thinking of maybe having a will, you're not yet sure, have an asset register. So this is just a list of all your liabilities, all your assets, all your beneficiaries, pins of, M-Pesa, share certificates or anything else, so that you just have a map of your wealth. Because maybe you're feeling, I'm not yet ready to have a will, so maybe I can do this right now. Like, just have your affairs in order. You could also choose to give someone the power of attorney. This is, you choose somebody to run your affairs because you're mentally or physically incapacitated, maybe because of old age or something. And so even as you're thinking of writing your will, you allow a trusted person to manage your affairs. Yeah.
Okay. What is the procedure of doing succession of an ancestral land with 5 wives? Each and every household was given a parcel by the deceased. However, one household is uncontented.
Sorry?
What is the procedure of doing succession of an ancestral land with 5 wives? Each and every household was given a parcel by the deceased. However, one household is discontent.
So was this done is this an instant succession?
George, you may need
Because the
to
answer,
establish that further.
yeah.
Yeah. Richard, I don't know whether you've seen this question. Where do side chicks come in here?
Okay, okay. Maybe, and I get this question might be coming because at some point in 2023, one of our legislators had proposed a bill trying to exclude people. But remember, like I said, anybody can claim that they were a reasonable dependent if they can prove that prior to the death of a deceased person, they used to be maintained by this deceased person. And so if I can show that prior to the death of a deceased, I was, having my rent paid, this man was taking care of my child, all these things, I can come and claim from his estate, whether or not I was legally married.
Okay. What happens if you are separated from your spouse and you are investing, you are legally married, but separated? What happens to the property?
If it's just separation, like we're not living together, they will still be entitled. The only thing that would make them not entitled is if there's a legal divorce that has been carried out. So you are legally married, now you're legally divorced, because former wives cannot inherit from you, especially if there's a, clear declaration. Yeah. And so if you're still, trying to see whether things could work out at some point, that's different. However,
What if you're separated for like 5 years?
That is not a
apart?
divorce. That is not a divorce. You are still married to each other legally.
Okay. Okay, the
Yes.
clarification on the car. My father handed me vehicle logbook and told me to keep it. The transfer didn't take effect and he passed away. In the written will, there's a clause of inter vivos. How can that be handled?
Okay. And so the car should generally pass to you. So in the written will, the clause of inter vivos, is it that he's handed the gift to somebody else, or is it providing that you are given the gift? Because if it's providing that you are given the gift, then that is now your car. And so that should be sufficient enough. Once you get the probate forms taken out, that should be sufficient to take to NTSA to register the transfer in your favor.
Okay. And at what age, Jacinta is asking, would you write a will?
In Kenya, I believe you're an adult at 18, and so you can start your will at 18 years.
Okay. What would happen if some members are discriminated from a will?
Yes, the court provides for reasonable provision, but I would need to know what kind of members we are talking about here. Many times it's just the immediate family that benefits greatly from the will. Yeah, it is unlikely that a testator is going to gift or to will a large share of his assets to a non-family member. And so if you feel like as a family member you've been discriminated against, then yeah, definitely. But even in the writing of the will, maybe I should mention, you could have a last wishes where you're saying, I am giving so and so this much because they would take me to hospital every other day. And so they deserve more than so and so who was out of the country. That's the kind of freedom a will allows you to have in who inherits what from you.
Okay. By the way, there was a question on somebody out of the country. But before we get there, there's another question here. What if we are divorced? I'm a former wife, in brackets,
Yes.
but the deceased still provided for me until his demise. Am I entitled to claim his assets?
And that's an interesting question. I would need to get back to them. but you're a former wife who is legally divorced, is it that you are they were maintaining you because of alimony? Because even that would lapse, because alimony lapse upon the death of somebody or a change in circumstance, say you get married to somebody else. So it is unlikely that the courts will agree for you to be provided for upon his demise.
Until, what if it's a case of child support or stuff like that?
Yes, child support is different because remember, a child and a wife are distinct people when it comes to the law of succession. A child, even if their parents were never married, a child out of wedlock is still a dependent of the deceased, whether or not they were being maintained by the deceased prior to his death. And so a child of whatever, of whatever circumstance they came to be in this world is a dependent of the deceased.
Okay. If a Kenyan woman is married to a non-citizen, can the country laws look into me as a husband to benefit from my wife's paternal or maternal wealth?
If a Kenyan woman is married to a non-citizen,
yes.
Yes.
Can the country laws look into me as a husband to benefit from my wife's paternal or maternal wealth?
So like a grandmother or a grandfather?
No, like I am married. So for example, I'm married to a Ugandan. Can the Ugandan inherit or inherit or be part of the will? Yeah.
Yes, it does. It does not discriminate citizenship. A will doesn't, not only a will, the courts won't discriminate where you're from. As long as you are the legal spouse to this person, yes, you shall be entitled to a share of the estate.
Okay. Further question on the separation. What happens if you are not legally married, but you cohabited and got children and acquired properties together, but later separated?
So is this matrimonial property we're discussing? If we're discussing matrimonial property or succession, the answers are different. So if we're discussing matrimonial property, you cohabited with somebody. One, for you to have a claim on matrimonial property, you have to show that you are legally married and legally divorced, and now you're coming to claim what was yours prior. Children's support is very different. It comes in the children's court, is not an ambit of division of matrimonial property. However, it can come under succession where your children will be provided for in the succession of this person. But if you're now legally separated or because you cohabited, that means you are never married, you go to the children's court and you file a suit for maintenance.
Okay.
Yes.
George is clarifying the case on 5 wives. The person died 35 years ago. The 5 wives was shown their demarcations, though the entire parcel is under one title deed. How do these 5 holds initiate succession? During succession, must the land be redistributed equally, or the demarcations of the deceased will stand?
If the demarcations of the deceased were through a valid written will, yes, they will. If it was an oral will, unfortunately, right now, they would not stand because I think you mentioned the person died 35 years ago. And so the court would try to equally distribute among the 5 households.
Yeah, and I
unless
think
unless there's compelling evidence to show, that a certain household contributed way more than certain others. Maybe the wife of a certain household was the original one and this property was all acquired prior to these other people, then that's different. Again, many of these cases stand on their facts.
Yeah. And for some of these things, for clarity, please email Mopa. She has shared her email address on the chat, so that you can get further clarification. Can one write a will on where they want to be buried? Yes, you missed that one.
Yes.
Say parents are separated or father was absent, but most times the father comes to claim the body upon death of the unmarried child. Will that be honored? Will be honored?
Like I said, there can be a bit of a clash between cultural aspects and the modern legal requirements. And so based on the exact nature of that case, it could go either way. Just because as a father was absent in a child's life doesn't negate that they were that child's father. And so maybe culturally, it could have an impact as to how the courts decide this. Because remember, unless your cultural dictates are in contravention with the constitution, they are still law. Customary law is still law in Kenya as long as they are not in contravention with the written laws of the land. But they are still law. Yeah.
Can you legally distribute all your estate property before your death to your beneficiaries to avoid the succession? I think that was the whole class. Where were you?
Yes, we answered that.
All right. I take note that we can never finish this conversation today. Richard, what do you think? We need to have a trust session, right?
Yes, this was the tip of the iceberg. It looks like the appetite for becoming advanced in understanding wills is quite high. So we will write an email to Mupa to come again and demystify other concepts that she has not been able to dive in. I agree totally that we need another take at this. Very important for us civilized people who do not fear death, who do not have that thought that once you write your will, that is another way of predicting your own death. So, yeah, yes, we do.
Thank you.
And hey, the questions are still, what does the succession say about division of the deceased estate among siblings?
Like I said, Section 66 provides for the list of priority. And the first one is the spouse, siblings, and then parents and siblings of the deceased come afterwards. And so if there's, a spouse and children, they will have priority compared to these other people.
Absolutely. Mupa, we are about to get to your parting shot. We are really, really pressed for time and we really need to come to a close. For those who are asking for presentation, we will share with you the recording for you to get a gist of what is happening so that you can also get to understand. Sometimes presentations only don't help. You also want to hear the interpretation of the concepts. So we will share that. Please subscribe to our YouTube channel. That's where we will upload the recording. Get It Right with the Tara Solutions. That's our YouTube channel. And of course, if you're in our WhatsApp group, Get It Right with the Tara Solutions WhatsApp group, you know that the recording will be shared there. So Paul, I'm sure, is right now sharing the links to all those sites I'm talking about. And of course, you're welcome to the performance management webinar that's happening on the 16th of April from 2 to 5 o'clock at only 3,000 shillings. Parting shot, Mupa.
Thank you so much for having me at Tara Solutions. Guys, please don't be shy to have your affairs in order. Like we said, it's not only upon your death. You might get incapacitated because of illness, old age, whatever. Accidents happen all the time. You want to make sure your beneficiaries and your property that you worked so hard for is well taken care of and doesn't fall in the wrong hands. And so please feel free to reach out to us. We take on a lot of family matters, not limited to estate planning and succession. I've had questions on division of matrimonial property, children's matters, that's in custody and maintenance. Please feel free to reach out and we should be able to come up with a working solution. Remember, we go at a client's pace. So if you feel maybe you don't have enough, the little you have worked hard for, and it doesn't need to go to the wrong hands or get wasted in this economy. So thank you, and I look forward to hearing from you guys soon. Have a good night.
Thank you so much, Mupa. This was really, really informative, and we take note that the comments as well. I think we wish we had more time. However, you've really done well in the time that we've had. So thank you for agreeing to do this, and I really hope that the guys can reach out to you so that you can get to draft their wills as well. And also help them in how they can manage the succession parts of their business. So thank you very much. Our audience, we cannot do this without you. We really appreciate you taking the time. And of course, our partners, Herbert Zakeh of Steadfast Quality Solutions. Thank you for bringing Uganda to us. We don't take it for granted that you spared your minutes to do that. And of course, the team at Atara Solutions, thank you so much. We can't do this without you. And of course, pass our regards to O&M Law for also your support and also just having you here. Thank you so much, guys. And we see you next Tuesday, same time, same place, as we cover yet another interesting topic on really matters that affect you as an employee and an employer. Thank you so much and have yourselves a lovely, lovely weekend. It's Easter weekend, so have fun and get some rest. And we shall see you on Tuesday. Make the time to be here. Asante sana and have a good night. Please follow us on Instagram at Atara Solutions, like our Facebook page at Atara Solutions, connect with us on LinkedIn at Atara Solutions, subscribe to our YouTube channel, Get It Right with Atara Solutions, and join our WhatsApp community, Get It Right with Atara Solutions. All the links to this have been shared on the chat here. So please, if you want to know what's coming up next, please do spare some time to be here. Asanteni sana and good night.
Have a good night. Thank you.